Now, one of the issues that the third respondent has brought what is a big pool. Yes, changing her name. Is alleged that the big pool was dated 17 April. And we are saying, my Lord, from the face of the record, that big pool has cancellation. 2012. This big pool has alteration on the face of the record, in the names.
Yes.
The face.
The submission of that is
This big pool should not be allowed since it's not countersigned. The third respondent also has attached a degree certificate alleged to have been issued by Pan-African Christian University. The petitioner had the opportunity to call the university. And one of the issues that came upon from the written affidavit is alleged that she joined the university in January 2018, and the degree reads that she graduated on 23rd October. That is 3 years, 10 months, and from 2 years, 10 months, and from our general knowledge, you know that a degree lasts 4 years.
not general knowledge.
Last 4 years. Now, my the petitioner called the university to an inquiry, which the university confirmed that the degree is not taken.
What are you going to do?
I'm pointing to paragraph 5 of the further supporting affidavit.
How did the embassy confirm?
It was through a phone call yesterday because of the time. Further, my Lord, the petitioner.
Please, don't do that. Don't do that. You force the court to exclude.
Further, my Lord, the petitioner did not go further to file any other documentation in support of the degree.
The petitioner or the respondent?
Sorry, the third respondent, which would be a letter of admission, and she joined, it's just alleged that she joined on January 2018. The transcripts.
Who has the burden of proof here? I just want you to have it in mind.
Yes. And any other documentation to that respect. The petition has also attached a certificate.
The respondent?
The third respondent has attached a certificate from Kenya National, alleged from Kenya National Qualifications Authority.
Kenya National
Qualifications Authority.
Authority.
This is a body established by law earlier by the petitioner, and which has been disputed from Kampala University. At the time when the petitioner was submitting her forms for Hearing-Meru County Women Representative, that is the IDC self-declaration form dated 24th May 2017, she declared that her highest level of qualification was a certificate in county governance from Meru University. Then how come again she had graduated with a degree in 2011? Under paragraph 10, in response to the fourth respondent's reply affidavit, again the petitioner had an occasion to find out on the allegation of the degree certificate attached from Hearing-Meru University. And it was found out that
From Hearing-Meru?
yes,
Hearing-Meru.
the petitioner's file does not contain his whole level certificate. So
You have something from Hearing?
again, it was through the petition.
You want me to rely on phone calls? Phone calls?
At the opportune time of the hearing, we shall present the documentation from them.
Phone calls will be removed. The court does not have to go.
True, my lord, but we shall avail written documents. Only that the issue of time was
Established that the Form 4 qualifications did not exist. Is that what you say?
yes.
And this was by phone call. Yes.
That's all on my part.
You have 1 minute, which you can run up any dot, or you can make to the other side.
No, I can't, my lord. The gist of the petition, my lord, is that we are
This
challenging.
is Mr. Mutegi.
This is Mr. Muteki, my lord.
Mr. Mutegi,
Yes. The gist of the petition, my lord, it is on the eligibility of the third and the fourth respondents to vie or to be nominated for the gubernatorial seats of Meru County. Your Lordship, we are stating that they are not qualified for the reason that they have no degree certificates. Your Lord, a degree, it is not an overnight event. For one to attain a degree, for eligibility to be admitted to university, one has to be a Form 4 giver or have qualified for all levels, my lord. None of the respondents, the third and fourth, my lord, has used his secondary education qualifications to support that they qualified, your lordship, to undertake a degree at the universities where they are wished to have studied, my lord. Turning now, my lord, to the issue of jurisdiction of the courts.
I love that was disposed of by line.
I have only a few issues, my lord, and yes. This court is closed to the jurisdiction, my lord. Article 165 of the lordship is clear that the court has unlimited original jurisdiction in both criminal and civil matters. Our petition, my lord, is hinged on Article 38, among others, on political rights. That is essentially the right to a free and a fair election, my lord. The main question, my lord, is if the third and the fourth respondents are allowed, without being qualified or without verification of their academic qualifications, to vie for the gubernatorial seats, will the election that is slated for the 9th of August 2022 be free and fair, my lord? The answer is that the election will not be free and fair. An election, my lord, it is a process and not an event. Whatever the IBC is undertaking, the nomination of candidates, it is part of the election. Therefore, my lord, we cannot be tied to the position that we cannot be heard in courts, and only the IBC that can hear us. We therefore urge you to hold that this court as the requisite jurisdiction to hear and determine our application and petition. Lastly, my lord, the IEBC has implied, indicated by filing of the application that this court has jurisdiction. Essentially, the application, my lord, seeks to have the matter transferred to a greater bench, an high court of equal status to this court. Therefore, if it is being transferred or being sought to be transferred to an equal court, it essentially means, my lord, you have jurisdiction as the same as the greater and partner here. Matters of this nature by the Chief Justice. We therefore humbly pray that you allow our application as prayed for.
You recall, Mr. Mwangaza, that the IEBC is neutral.
Yes, ma'am.
They have not taken any side on the matter.
I recall, my lord.
They have said that.
Yes, ma'am.
So they will not support your application or oppose it.
Yes, my lord. But the implication of filing of the application, my lord. That is what I was dealing with.
Mr. Mwangaza?
Thank you, my lord.
In response to the application by Mr. Mwangaza and in urging your objection.
Okay, my lord. We will start the response to the application. Lord, the petition. Seeking orders to bar the first and second respondent from accepting
Petition. Regarding the petition, that's okay.
yeah, in the application.
In the application.
In the application, the notice of motion application, they want you to bar the first and second respondents from accepting clearance documents.
Looking at
Prayer number 2.
yes,
Prayer number 2. Processing nomination certificates
yes.
or clearing the ballot for the respondents. In supporting the application, my lord, the petitioner states that they have investigated. It has been submitted before you, but they have said we have investigated. My lord, it is a submission that much has been done that they are not they do not have that wherewithal to investigate. There is no report, investigation report that has been tendered before you. Out of the investigation, to confirm, it means that the third and fourth respondents do not have the requisite qualifications. It's that the third respondent is about to use a fake degree certificate to present to the IBC. That's the first and second respondent. The the ABC and the returning officer.
Referring to a particular paragraph of the letter?
Yes. When you look at the body of the certificate of agency, the hearing and the certificate of agency, they say that paragraph 4, that on the strength of the same fake academic documents, the third and fourth respondents have now commenced the process of clearance. In the supporting affidavit of that application, notice of motion, you realize that they have not even bothered to attach the impugned fake certificate. There is none. They have approached you, they want you to bar the third and fourth respondents from presenting a fake degree certificate which is not attached, even for the consideration of this honorable court. My lord, in the supporting affidavits, specifically paragraph 8 of the supporting affidavit, yes, it reads that annexed and marked PMK3 is a copy of the fake degree certificate.
The reference to the degree certificate.
Yes, my lord, I will want to turn with you to the BMK3. BMK3, my lord.
BMK3 is
What is that, my lord? A screenshot. It reads screenshot
an announcement.
of an announcement.
Yes. You're saying the degree certificate is not right?
That is not degree certificate. My lord, it has also been, they have also stated that they have followed up and investigated and found that they got a response from Kampala International University. There is an impugned letter there. The same letter, my lord, is not addressed to the petitioner. It is addressed to one Francis Surukia. The petitioner is Dixon Mwangaza. My lord, they have drawn your attention to the content, the body of that letter, which is dated April 5th of 2022. And the heading of that letter is Inquiry on Academic Papers for Faith Kawira Mwangaza. Not
It is different?
5th April 2022. Yes, my lord.
April 5, that's how it's.
Yes, April 5.
April 5.
Yeah,
I have it. I have the reference.
It reads Inquiry on Academic Papers for Faith Kawira Mwangaza. My lord, when you post there, the question that academic papers, is it an academic thesis? Is it a dissertation? You cannot tell what academic papers that they are seeking to inquire on. And then they are saying reference, the letter also makes reference to another dated March 23rd, 2022. My lord, that letter is not attached. It has never been placed, has not been placed before you, before this matter. Paragraph 1 of that letter, BMK 5. Yes, dated March 23, 2022. That letter is not attached. You cannot tell what inquiries were being made. Lord, it is common knowledge that the body and the institution that has been granted the power and mandate to carry out investigation is the Director of Criminal Investigation. Before you, the petitioners have not shown you anything, any scintilla of evidence that they have made a complaint to the Directorate of Criminal Investigation so that they can undertake their mandate of investigation. In fact, they undertook the investigations themselves. That is what has been told before you. And our submission is that they do not have that skills. My Lord, the petitioner does not have any skill for investigation.
You need to have private eye. Let's do that.
Sorry?
Let's do that. Private eye detectives.
I believe they are.
One famous one.
I believe they are. But the petitioner, we have information, and I'm stating this from a point of knowledge. The petitioner is an ECDA teacher.
You're saying that he is not a private eye.
Yes, he's not a private eye. He has carried out the training of a kindergarten teacher, ECDA, early childhood development.
Would it make a difference if he was a private eye?
It still won't make a difference because there is a body, the Directorate of Criminal Investigation, that they should have.
I'm taking it from there.
Yes. And further, my Lord, there is also the Kenya National Qualification Authority. This is a special body that has been established by the Kenya National Qualification Framework Act, number 22 of 2014. Qualification Framework Act, number 22 of 2014. This is a body that has expertise, that has skill, and the machinery to verify academic qualifications. My Lord, the petitioner never bothered to write to this particular body. We did their work easier. In our replying affidavits, my Lord, we have attached letters the replying affidavit of the bank respondent. We have attached letters from the Kenya National Qualification Authority where they are confirming that the bank respondents with the degree certificate of Bachelor of Education with Guidance and Counseling from Kampala International University has been verified. There is a certificate of qualification verification. That is what it's called.
And it is in your document as exhibit. You are going to ask now,
Yes, Lord, I will I seek to also maybe summarily indicate the other documents, the annexes. Due to the constraint of time, I may not be able to refer to them specifically. My Lord, we have attached a degree certificate of the third respondent, Bachelor of Arts in Transformation Church Leadership, which was granted on the 3rd October 2020. Pan-Africa Christian University. There's a graduation booklet, my Lord. Yes. There's a graduation booklet of Pan-Africa Christian University, that 9th graduation ceremony. You introduce there and you find the name of the land respondent. My Lord, there is a letter from Pan-Africa Christian University to the Director General Recognition, Equation and Verification Department, to Kenya National Qualification Authority, on verification of the Bachelor of Arts degree certificate for Mwangaza Kawira. They have confirmed, apart from issuing this degree, they have confirmed to the relevant body, that is the Kenya National Qualification Authority.
Where is it?
It's dated 15 February 2022. My Lord, there is also the Certificate of Qualification Verification from Kenya National Qualification Authority.
Certificate of
Qualification Verification.
Verification by Kerry.
Kenya National Qualification Authority still. It verifies the Bachelor of Arts in Transformational Church Leadership for Pan-Africa Christian University. I wanted to Kawira Mwangaza, the land respondents. My Lord, there is also Commission for University Education, where they are confirming that these 2 degrees that have been issued to the land respondents, they are indeed degree recognized. They are degree recognized by the Commission of University Education. Take note that the time period that was not sufficient to warrant an award of a degree. Commission of University Education has confirmed that the degree as orphaned, it is a recognized degree. Data from the Office of the Director of Academic Affairs, Kampala International University. Much as they have stated that they have their letter, we also have our letter. Dated 17 February 2022. Yes. On verification of academic credentials, where it confirms that Faith Kawira was a student of Kampala International University, and she successfully completed her studies and graduated on 11th November 2011. She did not only complete, my Lord, but she was successful. On 11th November 2011. So, my Lord, basically, the petitioner have failed. They have successfully failed.
Anything you are saying about the
Yes, my Lord. On the 4th respondent, there is a replying affidavit dated 2nd of June. And it also confirms.
Let me tweet and I will read it.
Yes. It confirms there is a copy of degree certificate, a Bachelor of Biology, 2nd class honor upper division from Kenya Methodist University. My Lord, it has also been authenticated by the Kenya National Qualification Authority. There is a certificate to that effect. And a letter dated 13 April 2022 confirming the same. 13 April 2022 from Kenya National Qualification Authority. And there is also a letter from Commission for University Education dated 9th March 2022 confirming that the degree issued is valid and it's recognized.
Is that right?
Yes,
Later,
9th March 2022. So basically, the Lord, that in summary, is that the petitioner has successfully failed the evidential threshold to warrant the grant of the interim order sought. Now, my lord, I'll shift to the PO. Because time is running.
How much time? 2 minutes, I want to go to 5.
Okay, my lord. Article 88 of the Constitution and Section 74 of the Election Act 2011 is to the effect that the IEBC is granted the powers, the original and exclusive jurisdiction to hear and settle all pre-election complaints or disputes arising out of nomination process. My lord, we have authority this nature. And
You have found a list of authorities?
we have not found a list of authorities, but I want to. There is Godfrey Mwaki Kimathi and 2 others, as is Jubilee Alliance Party and 3 others. Jubilee Alliance Party and 3 others is 2015 EKLR.
You have copies for the other side?
Unfortunately, I don't have copies for the other side.
How do they know you're going to say, please?
That's the law, my lord.
How do they respond?
I will undertake to serve. And that is the law, really.
They need to respond now.
My lord, I'm quoting this as the law. It's a precedent.
Yeah, but they need a copy.
Yes, my lord.
I'm going to call them to respond.
Yes, my lord.
Okay? Which is the other one? Give them your copy.
The other one, my lord, is Jamle Mureithi Mwenda versus Law Society of Kenya 2010. I mean Law Society of Kenya. It's a 2022 EKLR report. 2022 EKLR.
Yes, next one.
There is Sami Dungu Whitey versus Independent Electoral Boundaries Commission 2019 EKLR.
That's it?
Lord, Article 88, sub-Article 4E, it's clear in the terms that it uses that the settlement of electoral disputes, including disputes relating to or arising from nominations, shall be handled by the IEBC. You've been told that you have original jurisdiction.
Yes.
It is our submissions that courts have time and again refrained from handling jurisdiction, matters where the statutes donates this jurisdiction to these statutory bodies. And the reason being is that these bodies are specialized in the nature of the disputes that get before them. My Lord, in the matter that I've put, the Godfrey Mwaki Kimathi and 2 others versus Jubilee Alliance Party, the court could end with approval on this issue that was dealt with by a 5-judge bench, the International Center for Policy and Conflict and others, that is the AG, where the court stated that it seems to me to be then beyond argument that the jurisdiction of the High Court can only be invoked if the minister, and in this case the committee, refuses to give a direction or is purporting to do so, arrives at a decision which is grossly unfair or perverse. So they have to demonstrate first that they have approached the body, that is the IBC committee, and a decision that is grossly unfair for them to warrant them approaching him a lot. I just remember that there is one issue that was raised about the deed poll, which I need to respond to. There is a gazette notice. Deed poll crystallizes into a gazette notice. That gazette notice has not been challenged on the change of name. We have attached that gazette notice.
Your 5 minutes now. Wrap it up now. Anything you need to say before I call on Mr. Mwangaza?
A minute.
Time is up, Mr. Sam.
Your Honor, there are issues they raised that we have not, issues on the phone call. They are not told us about.
The time is up on your side. Mr. Mwangaza took too much time. So I'm going to Mr. Charles Mwangaza. Mr. Mwangaza, for ADC?
Yes. Yes, my lord. My lord, we have found an application dated 9 June. That is today. That notice of motion, my lord, seeks referral of this matter.
But we are not urging it, Mr. Mwangaza. Is that right? That's an understanding?
My lord, do you want me to want it?
No, at this stage, because the respondents, back and forth, is it, Mr. Mwangaza? Say we are not ready to deal with the application for referral?
Lord, I believe the court gave directions on that.
Yes. So we are not urging the application.
And Mr. Mwangaza said that indeed his application touches on the petition.
Yes.
We are dealing with the application.
So I would like to hear you on if you need have anything to say on the application or the preliminary objection by the Madam Ford. Anything?
Nothing to say, my lord. We are not participating in this.
Yes, my lord.
5 minutes.
Yes. My colleague has stated that he did raise his nomination dispute and is relying on the prayer assault. Well, my lord, he has not that the body of the petition. The prayer assault is only a redress. The course of action is on the body. If you have looked at the petition or the application, the substantive petition of the application, you have established that indeed this is purely an issue of breach, violation, or a threat to breach of the Constitution. What we are seeking, my lord, is what borders the nomination. And the nomination, my lord, at 165 gives one a right. Your Honor, sorry, my lord, you've been challenged that you've not produced the documents, the academic certificates. But when you retired, right, you are ruling, my lord, we established that when a petitioner alleges that one is not eligible, it is the burden of proof shifts to the respondent to prove that indeed I am eligible, and these are the documents. That has been proved, my lord, in the petition number 16 of 2013, when the court will look at it at the opportune time. My lord, sorry, my lord. Documents have been produced from KNQA and Commission for University Education. I submit that this is another piece of fake document.
In your brief?
Yes. Make reference, my lord, to the document that is affordably approving degree of Bachelor of Education with guidance and counseling from Kampala University by the respondent, by the third respondent.
The body.
Sorry, KNQA.
KNQA?
Yes. It makes reference, it is dated 18th of January 2022, which identifies
the third respondent as Kawira Mwangaza as at 2011. Your Honor, the court should also take consideration of the alleged deed poll, which is also another forgery, which was done in the...
It should be shown to that as
Oh, yes, my apologies, my lord. Make reference,
in Kenya Gazette.
yes, my lord. It is dated 17th of April, 2012. The alleged degree does not bear the name Mwangaza. The name Mwangaza was not an official name of the third respondent as at 2011.
You think the degree doesn't have Mwangaza?
Yes. And as at 2011, the third respondent was not named as Mwangaza. That respondent and the fourth respondent have deliberately avoided the question of producing their O-level certificate and all other certificates. If indeed they are not as claimed, nothing would have stopped the court from producing nothing would have stopped them from producing these particular certificates. We have not established, we have not been served with a copy of the degree from Kampala International University. We relied on one that we had to screenshot. That is our DMK3. It is a screenshot, my lord, of that alleged degree that has been kept close to the chest by the third respondent.
Is it not an attachment here?
We have attached that. That's the only evidence of a degree we have, which the third respondent has completely failed to produce into a statement. What we have in her documents, what we have produced is what was available for, which was a screenshot from the third respondent's television.
And what do you see in the confirmation by?
Yes, that is where I'm headed, my lord.
Okay, and I told you the
yes.
time is up.
Yes, 2 minutes to wrap up, my lord. While KNQA and CUA does not have a mandate to verify a degree from a university. There's a court order, my lord, that has barred that. The time you read. The work of Commission for Higher Education to establish that a university is supposed to offer degrees recognized in Kenya does not go to the individual degree holders because they lack that capacity. It's only the Senate or the board of the university that has powers to indeed validate that this degree comes from us, this particular learner learned with us. There are two letters, my lord, for myself, from Kampala International University, from a Kenyan and a voter in Hearing-Meru, who has the right to university to establish whether that degree is legitimate or not, and another one that has just been produced for the year this year, February. The question of 2 degrees, the 2 letters emanating from the same institution, is what should make this court issue a conservative order to establish which one of the 2 is fake and which is not. That alone should persuade this court to issue conservative orders. Yes, in parting short, my lord, I ask this court to grant the conservative order as issue. There will be no prejudice if at all she is qualified. The only prejudice that will be occasioned is just a delay in the nominations. But on the converse, my lord, if the orders are not issued and the accused person, the petitioner is not qualified, there will be a whole breach of the constitutional rights, Chapter 6, violation of Chapter 6, and in general, my lord, an affront to the rule of law and justice to the judiciary. I ask the court to grant the orders as such. Thank you, my lord.
Yes, you've been urged that you have jurisdiction number 165 and 258 of the Constitution. It is in our response. states that Article 165 and 258 of the Constitution is not a substitute or a means of excluding such other disputes. Section 74 gives the statutory duty to Mwangaza. And my Lord, the Parliament in its wisdom and being well aware of the existence of Article 165 of the Constitution, enacted statute that made for provision for settling disputes arising from or relating to nomination and election. And in the same enactment, my Lord, the legislature anticipated the existence of such disputes. And that is why it created necessary and specialized dispute resolution fora. My Lord, for the people of Kenya to have confidence in their bodies, statutory bodies, it is only right for this honorable court to exercise judicial restraint and allow these statutory bodies to carry out their mandate. And a matter that is not right for these statutory bodies should not be entertained by this honorable court at this juncture. The court should exercise the principle of rightness, judicial exhaustion, and judicial restraint.